I think clarity and transparency on the front end from both parties would eliminate a lot of contractual disputes.
Today we have our very first guest, and we're very excited about it. We have Garrett Murphy. Why don't you go ahead and introduce yourself for us?
Sure. My name is Garrett Murphy. I am the owner and member manager of an LLC called Garrett Murphy Law LLC. It's a boutique law firm here in Evans, Georgia.
You see a lot of people online, especially in the photography industry, they like 70-page contracts.
Mhm.
That has just absolutely anything, everything in
It'll
it.
just
Yeah.
constantly be like,
I'm not liable if your kid cries type stuff.
Like I'm not
Yeah.
liable if your child starts crying and you don't get a good picture because they're crying, and the parents think, oh well, maybe we can try to reshoot it or something, and it becomes this like hard line to draw for a lot of people between professionalism and what am I legally obligated to do,
Right.
which it as a business owner, I think they rely really heavily on their contracts, and then they keep adding these little things like I'm not responsible if your child cries, or if you show up 10 minutes late, you violated my contract and I can leave. But then you kind of skip the professional side of being a business owner.
That's
and
right.
being understanding, and well, my contract protects me, so I should be good, right? So, like, what do you think about, situations like that where people have lengthy contracts?
Right. There's two sides to it, right? If I came in as a dad and had a 4-year-old, because I remember when we took my daughter's 1-year-old pictures, they were awful. I mean, it never crossed my mind to get my money back. I was like, it's not the photographer's fault. I mean, my baby was crying, and one of my favorite pictures of her is trying to smile while she's crying. I mean, but if there's a 70-page contract that I had to sign, I would be skeptical.
Well, is that because you're a lawyer, or is that,
Feels like a lot for a 1-year-old.
I would have to say, if it was a 4 or 5 page contract, I would probably skim it. Let's pretend I wasn't a lawyer. I'd probably skim through it, get through. If it was 70 pages, I would probably want to see it at least 3 days in advance.
Okay, so
And the reason being is my thought process. You're a photographer. You're going to take pictures of my kid. What is the 70 pages?
So
What am I signing?
A lot of times it's people who I think that the 70-page contract and the lack of professionalism kind of go hand in hand. And this just isn't in photography, or it's in any industry. People can make their contracts very lengthy,
Absolutely.
very like lots of bullet points on there that they're not responsible for. But does that take away the responsibility of the photographer if they say, if you get bit by a snake in our photo shoot, we're in this field, I'm not liable. So that's just an example, but
Yeah, that's a great question. Can you contract away? So let me tell you, as an attorney, I can't contract away. I can't have a client sign that says, if I do a really bad job, if I never return your calls, you can't sue me. I can't contract away. I can't do that.
if somebody
That's
came to you
against
though,
public
and
policy.
said I was shooting with this photographer and they, I got bit by a cottonmouth or something during the photo shoot, and I want to sue them now, but I signed this contract that said they're not liable if I get injured or sent to the hospital or something.
Okay, great question. So it depends. That goes in a lot more detail. It depends on a couple of things. Was it on your property? Were they invited to your property? Because then that makes them an invitee. And when they're an invitee, you have a higher standard as the property owner to make sure that all of the latent defects or known defects, whether it be a rattlesnake home in the back, whether there's a pothole to fall in. To take the example of, you invite people over for the Super Bowl, somebody gets too drunk and somebody, slips and breaks their neck in an area of the house that's being redone. Cases like that are all over the place, right? You can contract away some of that, but when you're inviting them into your house, they're invitee status.
So
or to their property.
If you're on, say you've rented this property, so it's not your property as the business owner. It's not the client's property. You've rented this from a third party, and now assume that you do have liability insurance as well.
Yeah.
So they would technically sue your insurance because you are an LLC, right? So they can't sue you personally because you've taken care of that correctly. What is the specifications? Like how how can you protect yourself in that case besides having a 70-page contract? Is there any way that you can prevent being sued if something like that
So,
were to happen?
yeah, there is. Number one, it would depend on the relationship between the space, the contract that from the property owner and you as the photographer who you're renting it from. Typically, what you see is what's called boilerplate language. Boilerplate is just generic language, okay? And a lot of these longer contracts have extremely long, sometimes unnecessary legalisms being herewith, therefore,
Unto all the prepositions.
Oh, yeah. And I admittedly use them to this day sometimes.
Well, I feel like it's kind of expected when you go to get a lawyer contract or something drafted up. Like it's always in this really fancy kind of like language that sounds professional.
So that you bring up a good point. There is a matter where the language of. So let me back that up. Kind of where we were earlier in some of the topics here. When you sign an operating agreement or you sign a set of bylaws, that's a legally binding contract between the owners of the company and the company.
If I text you, hey, if we meet at this time at say 6:00 and you're 10 minutes late, I have the right to leave, and the person responds or doesn't respond, is that a form of a contract also?
It can be, right? So in order to have contract, you need to have offer, acceptance, and consideration. So offer, I'll pay you $300 to paint my fence red. Okay. So there's an offer, and the consideration is for you painting my fence red, I'll give you $300. If you don't respond, or if you don't respond, then there's no acceptance, right? Sometimes there's acceptance and silence, but I think that the case law is very vague on that. You typically want an affirmative acceptance. And also what's important is material term, okay? If you're going to be 10 minutes late, I have the right to leave. It's non-refundable. I would make sure that is in writing. I think that would be, I would argue that's a material, no matter what side of the V that I would be on, I would argue that that's a material term, refundability versus non-refundability.
What about non-refundable deposit and a non-refundable retainer?
So all of these things fall under the ability in Georgia called freedom to contract, right? So what ignorance is not an excuse to get out of a contract in Georgia.
So if I took a non-refundable deposit to mean that I couldn't get my money back, but somebody else took it to mean that if the session didn't happen or the fence wasn't painted, where, like, you see how it could get.
Absolutely. That brings us to a really good legal point, right? It's called ambiguity. So one of the most important things you can do in a contract is try to make the language as clear as possible. Non-refundable if you're 10 minutes late. However, if you call 24 hours in advance and let me know you're going to be 10 minutes late. Because what happens if it's found that a contract is ambiguous, then in other words, it lacks clarity. The term has more than one meaning. Then it can go into the court system. There's a statute that governs ambiguity and other issues in a contract. And if it's ambiguous enough, it can go all the way through a court and through a trial and through a jury.
I see a lot of times people saying, don't call it a deposit, call it a retainer, because, if they sue you or they try to get their money back in small claims or whatever, that if you called it a deposit, they won't. And there's a lot of kind of conjecture on what your specific wording means. But I think, like you said, you have that ambiguity there where it comes down to what the intention of that was, right?
Yeah, right.
Did you clarify what that meant? So if they said the word deposit, maybe the judge would side, okay, yeah, they do get their deposit back or their retainer or whatever it is,
right,
depending on the conversation and the context of
those
that.
could easily be interchangeable words.
Right.
Yeah, that's right.
But people put so much weight on it in these groups that I see.
Well, like in your profession, retainer means something totally different than in my profession.
Right.
Right. I would never tell somebody that they're giving me a non-refundable retainer, because a retainer means for future services. Mm-hmm. If that service is not performed, then how can I refuse to refund that? In my business, that would be deemed unethical. If you say it's a non-refundable deposit and the terms are completely clear in the contract, and let me say, there's no such thing as the perfect contract. There's really not, because what you have is two human beings or two entities comprised of human beings trying to come together to reach an agreement. There always is room for dispute and conflict. But you want to make sure the material terms, non-refundable deposit, what does that mean? That means A through Z, clear. And that, and a lot of times in these material terms is when we start getting into legalese and big words, it can create ambiguity, right? So the message needs to be clear. The language needs to be short and concise. There are certain parts where the language needs to be, and again, what I call legalese, right? So if in an employment relationship, termination for or without cause, that's an important legal saying. Time is of the essence. That's an important legal saying. That basically means, if that's not written into a contract, that's saying that there's no time limit on it. Time is of the essence means it should be done as soon as possible. Or in the alternative, the photography shoot would be done in 90 days.
I didn't know that time was
I didn't either.
a legal phrase, actually.
You see it in a lot of contracts because what it does is, again, let's kind of look at the foundation of it briefly. In Georgia, you have freedom to contract. Ignorance nor drunkenness is ever an excuse to get out of a contract. You can enter into a contract as long as it's not against public policy, right? As long as it's not against the well-being and it's not against statutes, or it's not an illegal contract. Other than that, if it's not, other than those two caveats, against public policy or an illegal contract, you have freedom to contract. And what that means is the terms don't necessarily have to be fair. If a client argues that the non-refundable deposit is unfair and he or she is not going to enter in that agreement, then that can be negotiable. You can say for this one client, all right, then the deposit will be refundable.
Doesn't that come down to professionalism and
Absolutely.
not the contract itself?
Absolutely.
Like you see a lot of people, I see a lot of people always just like, what does your contract say? What does your contract say? And at the end of the day, like, word of mouth, like it gets around, right? Like if you're going to stick to your contract at every single issue that you run into or add to it or something, like it's my opinion that sometimes being professional is worth more than the deposit that you want back or the deposit that you want to keep. Like, does it set a sort of when you have yourself legally protected, right? You can kind of afford to accommodate people, and knowing that if you didn't, like if you say no, I feel entitled to this deposit, then you could keep that and have an argument, right? And it would be a serious matter and not just I'm being petty and I want to keep your deposit.
So yeah, that's a great point. That brings up two issues, right? A non-refundable deposit, let's say it's $500. Is somebody going to sue you for that $500 in small claims court? They certainly could. But if the contract's good, if the contract is clear, then they can't sue you because the contract was unfair because they've had the right to read it. Mm-hmm. You've got to protect your business. Or, you could be talking about a non-refundable deposit of $100,000. Then we start getting into, deeper contracts that outline specifically what that means. But the question then becomes, did both parties understand what the word non-refundable means? Ignorance can't be met. The person that doesn't want to pay that non-refundable deposit has the, I would argue, obligation, but certainly the right to read that contract before signing it.
Do you think that a conversation and an opportunity to ask for understanding and like, yes, I understand that, like a conversation is worth anything when you enter a contract?
Absolutely. I think clarity and transparency on the front end from both parties would eliminate a lot of contractual disputes. I really do.
And like when you buy a car, do you read the entire contract that you're signing, right? Like people don't read contracts.
That's right.
People they just don't.
People don't. And there is, I would argue, anytime you're doing, if you're buying a ticket to a Braves game, maybe you don't need to read all the terms and conditions. But if you're buying a car and you're buying a house, you need to know the ins and outs of it. You're entering into a business with somebody. You need to know the ins and the outs of it. Because again, most important, remember, ignorance is not an excuse. Mm-hmm. Because you have the freedom to contract, that also means you have the freedom not to enter into that contract, right? Let's say you have a photography studio and a client comes in and she doesn't, or he does not like the terms of that contract. She or he have the ability not to sign that contract and go somewhere else, right? And I think that's vitally important. Other contracts, let's say like insurance, okay, auto insurance, home insurance, business insurance. What you get before you sign it, you need to understand not only what's covered, but perhaps more importantly, what's excluded. Now, that's called a contract of adhesion. Okay. That means that contract's not necessarily negotiable. Another way to say it is take it or leave it. Right. So when you get insurance, you can shop around at the most multiple carriers. Typically, people look at it for the sake of premiums, but they also need to understand the coverages and the inclusions. What you can't do is typically is go back to the insurance company and say, I don't like section 43D subsection 1, take it out. They're just going to say take it or leave it.
Do you think that's because of their size and the establishment of the insurance company, or do you think that's just an industry standard?
So both. I think because the insurance industry has so many clients that it would not be profitable to them to negotiate every contract with everybody. However, under Georgia law, the drafter of a contract, if there's a dispute in a contract, the person who did not draft the contract is viewed more favorable by the courts. So let's take a real world example. Two people enter in contract. One person drafts that contract. The other person reviews it and signs it. There's a dispute in that contract. The court is going to look at the person that actually drafted that contract and say, well, there's ambiguity here. You're the one that drafted it. So it's not foolproof and ironclad. But if you go into a contract dispute, you don't necessarily want to be the one that drafted it. With insurance companies, because they're contracts that aren't necessarily negotiable, the courts look at that element, that idea of law, and they take it very, very seriously. So I go into a dispute with an insurance company. The insurance company has their contract. There's an issue of ambiguity. The courts, based on case law, typically will look more favorably towards the person that didn't draft that contract. And so that helps balance out those scales of that take it or leave it approach.
And because of that, all the details that go into it and the fact that they do favor the person who signed it, do you recommend anybody write their own contract because of all the nuance that goes into it?
Well, that's a really good question. At some point, somebody would have to write those contracts. I would, number one, if I was going to give you a contract, I would not print it off online without reading it and hand it to you. I wouldn't just fill in the blanks. I would make sure that it is customized. Typically, you can get legal counsel that can review a contract at a relatively low cost just to make sure there's important things in there. Like we were talking about earlier, one of the biggest issues is liability. Hold harmless, release agreements, indemnity agreements. What happens if this happens? What happens if X, Y, or Z happen? That language can be the difference of a successful contract or not. So I wouldn't tell people to shy away from entering contracts because, quite frankly, having a written contract is so much more powerful than a verbal contract. And here's why. We get into a contract dispute. I say, you said you're going to paint the fence for $100 and you're going to paint it red. You can say, no, you said it was $50, you're going to paint it white. It's just a he said, she said. So having it in writing, at the very least text messages, but certainly try to have something in writing. And if you're entering into a contract, if you're a business owner that's going to have a contract that you reuse and reuse and reuse, I would absolutely recommend that you seek competent counsel to review that for you.
What about websites like, I think it's called like Rocket Lawyer and stuff like that, where it is kind of like a fill-in a template and they let you just take it for like $50?
You're the one so they've provided the template for you, but you're adding where you can kind of get into that murky waters of, this and this and this and kind of that X, Y, and Z all the way down the alphabet list of, what'd you call them? Not exclusions. What was the word you used?
So I use contracts of adhesion.
Adhesion. Yeah, like there's adhesions in the contract. Is that right?
So a contract of adhesion is just one where it's non-negotiable, like the insurance company.
Right. So if you write it like that and use a template through Rocket Lawyer, it's going to have would you say legalese in it?
The legalese.
It's going to have the legalese. It's going to look legit. And then you're going to have all of these bullet point, pages and pages of, I'm not responsible for this, trying to waive liability from all of this, trying to talk about what the client is entitled to, what you're entitled to as a business owner, and down to I've even seen people include, the attitude that you have to give them during, their experience with you. Like if you come at me, tell me you don't like something that I did, well, you're in breach of contract. And look, I have this professional looking contract here. So
Right.
like how specific can you get? Can you tell people like, you can't treat me like that? It's against the contract that we entered here.
That's an interesting question, because let's say that section or article is in a contract that says you have to act a certain way. Unless there's physical proof that way was acted, how are you going to prove that? Right? Then we start getting into he said, she said. I think to your point, and I want to make sure I address it and answer your question clearly, there's a lot of websites, and a lot of those websites will say this is not legal advice. You are not, and be wary of that. Some websites will actually get you in contact with lawyers. I think for me personally, maybe a little bit more of a traditional view, but I believe that you speak to somebody face to face. Going back to something I stated earlier, you don't know what you don't know. Mm-hmm. Let's absolutely break down your business. Let's break down your goals. Let's put in language that may be fair, but also that may lean a little bit towards one way. What are your goals, right? I don't want to be taken advantage of. I don't want clients showing up an hour late. I want 50% paid up front. I want 50% paid on the back end. All right, what does that look like in an unambiguous way? What does that look like? What is language that has been tried and true through Georgia case law that says that no, this is not unambiguous? In other words, this is clear language. This passes the test.
So to put it simply, you believe that when somebody has a contract, they should have a legal representative helping them write it and not just using a template.
Absolutely. Yeah. If you're going to, especially from a business standpoint, I've seen a lot of them, and a lot of them are very good. They're very good for maybe generic things that don't have a lot of meat on the bone, right? But if you're going to have a contract that's going to be your client engagement contract time and time and time again, it is absolutely worth it to have a competent attorney, if not draft it, at the very least, review it for you.
Do you think the average person is capable of doing the requirements that you think should be there in a contract? You think the average person probably not be best suited for that?
No, I don't, and it's because repetition and experience. You see so many good contracts, but also in our line of work, people don't come to me and say, "Hey, I wrote this really good contract. I want you to review it." It's typically, "I'm in this contract dispute.
Yeah.
Here's a contractual issue."
They wait too late.
They wait too late.
Can you give an example of some contractual issues that you see a lot in your line of work?
Well, I'll tell you what I see. And let me remind you too, when you enter into an LLC or you enter into a corporation, when you sign the bylaws or you sign the operating agreement, you're entering into a legally binding contract at that point. Here's one of the biggest issues I see with businesses. And it's not necessarily with clients or customers. It's within the business themselves. It's called unanimous consent, right? So if you think about it, when you start a business and let's just take, there's two people start a business. They typically share the same dream, the same vision. They talk about it. They're excited. They've thought about it. And now it's ready to move forward. The business is ready to open, okay? They will print off an operating agreement online or decide that all decisions are just going to be made unanimously. Right. So in order for us to make big decisions, we have to get unanimous vote. Both members have to agree to it, or that action can't happen. That sounds good up front, but as the business grows, as it hits a rough patch, one of the biggest mistakes I see are businesses not having another alternative to unanimous consent. Right. It can create a roadblock, especially when the membership interest changes from 50-50 to 60-40 or 70-30 or 80-20, or you're looking at have outside investors come in, unanimous consent can be cumbersome. It can be a deal killer. A lot of people may look at it, potential outside investors, and say, you need unanimous consent. That doesn't make sense to us. That's one of the biggest issues I see, right? And I can relate to this as a small business owner. When I started my law practice, and still am very excited about moving forward and the way things look and the directions for the future. But when you start a business, put it this way, I've never seen anybody say, I can't stand this person, so I'm going to start a business, right? It's not till down the line where they hit this dispute and they can't agree on something, that these issues really arise. From the business context, that's probably the biggest one.
Do you think that establishing that early on saves relationships?
Absolutely. There's a couple ways to do this. You can either have it written in your operating agreement or your bylaws, depending on the entity, but have a buy-sell provision. Have a right of first refusal provision. Basically, in the event somebody dies, does the surviving spouse or do the kids get it? Or does the company have the opportunity within 30 days, 60 days to buy the deceased member's shares? In the event unanimous decision can't be reached, is there mediation? Is there an arbitration provision? Do we seek counsel from an independent advisor who's knowledgeable in that business area? Always have caveats, and caveats the wrong word. Always have alternatives when you're looking at something as stringent. I mean, if you think about it, business decisions can't move forward if there's unanimous consent. So have an agreed upon alternative.
What about for single party owned businesses? So like a one person kind of deal.
Right. So, and I'll touch on a couple topics if that's okay with that. So it's called, for an LLC, it's called a sole member. You're the only member of that LLC, and that is completely fine. That is totally fine. I'll tell you, Garrett Murphy Law is a sole member LLC. But what's most important here is that there's an operating agreement that's in place inside. Because when we're talking about liability protection, let's say you're sued in a lawsuit. How can they get through to your personal assets? If, let's say, there's insurance that's not included, or the damages, the amount of money they're suing for is greater than the insurance. They're going to do what's called piercing the corporate veil. They're going to try to prove that your business, your sole member LLC, is just the alter ego of you acting individually. So if you have a sole member LLC, I cannot stress it enough, make sure you have a signed operating agreement. That's number one. Now, for all entities, make sure that your bank account is separate. The business bank account is separate from personal bank account. Don't commingle funds. In other words, don't pay your family's mortgage or your power bill out of the business account. Make sure they're totally separate, okay? Don't fraudulently transfer property. That's another big one. If you think you're about to be sued and you fraudulently transfer property to a third party, those are really the three big ways that a plaintiff or somebody suing you can pierce through the corporate veil and go after personal assets. Again, very, very important. Have the operating agreement in place and abide by that operating agreement.
I think a lot of people are going to hear that and think, oh, well, that's not my situation. I'm just a small business owner. Like, I don't have, any real business assets, or I do, less than $50,000 a year or whatever. Like, this is just worst case scenario. It won't happen to me, right?
That's right.
So can you say like that it does happen to small business
Absolutely.
owners?
And let's just give some worst case scenarios. Small business owner, you own a corner store that sells cakes, or you have a brick and mortar shop that's a small space, and the revenues. One thing, revenues don't necessarily matter when it comes to a lawsuit. So somebody comes in and it happens to be rainy that day, and somebody slips on the floor and has a major injury. Even if you're your third day in business and you don't have any revenues, then that's still an extreme lawsuit. You need insurance. You need to have that LLC protection. Because let me tell you, if your business does not have the revenues or does not have the income, does not have the profits, they're going to try to find a way to, number one, get insurance, and then number two, go after your personal assets. So I would argue it does not matter what size you are. You need to make sure that you have your corporate documents in place.
It's all good because, I think a lot of people are going to hear what you're saying and think, oh, well, that doesn't apply to me because I'm just a one-person business, or I have, they're going to think, oh, my revenue isn't enough to care about that stuff. But then, like you were saying, if their revenue isn't even that large, or they're not bringing in, substantial income, then is it easier to pierce the corporate veil and come after their personal assets? If that's the case, is it harder if they are making more money?
So let me put on my plaintiff's attorney hat. If I went through a lawsuit and I noticed that the business was making no money, the business owner's personal assets were worth millions and millions and millions of dollars, then it would get a light to go off in my head to say, all right, perhaps they are just using this as a shell company to protect them from liability against personal assets. If you have your corporate governance documents intact and you abide by them for an LLC and operating agreement, abide by what the operating agreement says, your funds are not commingled, you haven't transferred property fraudulently. These are kind of the big three. You make sure you do these things and you're operating in good faith and in sound business judgment, then your assets should be protected. It doesn't matter how small or how large.
What are your opinions on people who are qualified or not qualified to be offering legal advice to a mass, like kind of unrefined audience? The only refinement is that they are likely in the industry that you're trying to target, and they're giving out legal and business advice and pointers. They use all these like trending sounds on Instagram and stuff to try to get into as many people as they can. And ultimately, it's not really free, right? They're trying to kind of hook you in, lure you in, and then sell you something.
Right.
How do you vet the people that are trying to do this, since it's so common?
So, social media, love it or hate it, seems to be here to stay and is a large marketing presence for probably all types of businesses now. I'll be the first person to tell you, I am not a social media guru. I know exactly what you're talking about. I see stuff. It's amazing. I don't do a lot of social media, but I'll get how to make a lot of money estate planning. How, here's all these leads and you click on it and they hook you in, but then you go to some website that has terms and conditions, that has all the necessary disclaimers on it. I would be cautious and make sure you do your due diligence before just jumping on the bandwagon.
So can you explain what some, good signs would be when you find somebody that's doing something like that? Aside from, a big social media following, what is something that these people can do that would make you feel like, okay, let me look into this a little bit more?
Social proof isn't always proof of anything.
Right.
I would say, number one for me as a consumer and also as an attorney, if something's too good to be true, it usually is.
What you mean that they're not going to make me a millionaire?
They're not going to make you. They're not going to make you a millionaire.
That's the newest thing I see is, do this, self-employed thing, and you'll be a millionaire in 365 days, and manifest it. And, don't worry about the specifics. And it's like people believe this though.
They do.
How? I guess that's frustrating because you can't hold these people liable for. You're selling your house to invest in their course and to continuously pay the monthly expense to buy their course, but they can't be held liable if you don't succeed, right?
That's right.
So where does it get into the kind of, can you legally do anything if somebody gives you bad legal advice, but with a disclaimer, without a disclaimer, as part of a coaching course or, steps that they think you should do to follow? For example, our podcast, we don't give advice. We just kind of try to go over some educational information, right?
Right.
But if we did give legal advice and somebody went out and did it and they got into legal trouble, could they sue us for that?
So could they? Yes. It would be an uphill battle, right? So you can get into criminal and civil trouble for holding yourself out to be somebody or not. Let me give you a prime example, contractors. We know there's a lot of fly-by-night contractors, unfortunately, in this area, and we see it a lot. People that hold themselves out to be certain things. Same thing with attorneys. Same thing with doctors. That's more on the criminal side. But these people on social media that I promise to sell you, you'll make $1 million, or if you follow these 3 easy steps to freedom and here's how I became a millionaire. I think what they're doing is skirting the line from offering you what's legal advice or real estate brokerage advice or medical advice and just saying, hey, here's how I do it. Remember that concept we talked about, freedom to contract, and ignorance is not an excuse. It is up to the average human being to make sure they understand all the facets. Now, if somebody, you hear a lot of this, and I won't go on a tangent here, but you hear a lot about elder abuse, right? People are calling it the elderly and saying, for $500, you'll get this.
Oh, yeah.
It's the same thing.
Scams.
It's the same thing. These can be scams. So they're not necessarily holding themselves out as financial advisors or real estate brokers or attorneys or doctors. They're just saying, hey, here's how I did it. I'll show you how I
If
did
they
it.
call themselves like an expert on the topic, though, like I'm a financial planning expert, or I'm a social media expert that will show you how to make,
even hold any weight.
Like, is there any qualification that you could argue that person needs to have to call themselves an expert?
Yeah, you could argue it. The question in practical terms becomes, how much time are you going to invest, right? So, right, you somebody online says, you pay $1,000 to me and I'll teach you how to be a millionaire in 90 days. So you pay that $1,000 and they hold themselves out, right? Are you going to file a lawsuit for that $1,000?
Well, chances are they're preying on people who are not in a financial
That's exactly
position.
Right. That's
so
exactly
they
right.
kind of are aware, in theory, that they aren't going to be able to sue them if it doesn't work out for them. But when they make these, it's like a promise. But even if they promise, like, hey, I guarantee you're going to be a millionaire, they could ultimately say, oh, well, you didn't do this right. Like, they could kind of gaslight you into thinking. I see it a lot in like MLMs, where they'll tell you, oh, you didn't girl power hard enough, or you didn't reach out to your friends and family hard enough. That's why you didn't succeed. And they kind of gaslight you to thinking that it's your fault and not their fault, actually, when like, you should be able to blame them, right? Like, but at the same time, can you? Like, it's not really their fault.
It depends on what they're trying to hold themselves out of, right? Financial advisors, real estate brokers, lawyers, doctors, you all need licenses. You have to pass certain tests to hold yourself out. The question would be more specific and customized. What are they holding themselves out to, right? And
influencer, it's kind of like a dangerous term.
Yeah, and if you're an influencer, there's no license required to be an influencer.
But if you know that you have this power of influence, right? Like, and you can, others can see you have this big following, wouldn't you have to be held liable at some point for how you act and the advice that you give?
You could start getting into consumer law and start getting into fair.
So like, there is a way.
There is a way.
It's just why is it done? Like, why is it done so often? Like, that people just tout themselves as these experts or these financial gurus or whatever, and how do they get away with it?
Well, I don't know the answer to that, honestly.
It's just something that's like a new trend.
It's a trend. It's a lot of people, for $199, that you can buy a book. You can write a book. I can write a book.
Yeah.
Mm-hmm.
You can write a book on financial peace or prosperity and how to be a millionaire. That doesn't mean you're holding yourself out as a financial advisor that's regulated under the securities industry.
So if somebody follows your book and they don't become a millionaire, then you're not responsible for that.
Mm-hmm.
That's right.
That makes sense.
Yeah.
Compared it to books really helps put it in perspective.
Because like, you can even get on the New York Times bestseller, pretty easily if you pay for the spot.
That's right.
Like, supposedly it's what I've heard. So I haven't done it, but like, it's they use like these fancy titles or these like made up kind of certifications that people recognize, and they get some kind of brand recognition that way. But it ultimately comes down to, I guess my question is it your responsibility? Like, are you responsible if you follow this guru or this this class and you don't succeed and you're out on your butt? Like, is that your responsibility?
So the harsh truth I would say is yes, right? It's your job. Ignorance cannot be contracted out. If you choose to follow somebody that has 1 million followers, that's constantly on Instagram riding around Ferraris and smoking cigars and doing all that, but they're not saying you're not retaining them to be your financial advisor, then you kind of have to. You can't play the ignorance card all the time.
That's scary.
It is. Oh, it is. I see it all the time.
Yeah.
Because there's a lot of manipulation that goes into that, and if people get sucked into it when they're in a low place, and so it is harmful, even if to a degree it's legal. So I mean, there is a separation there. I know we're talking about legal stuff here, but there is things that can be harmful and really shouldn't be allowed, even if they don't really break a law.
It's such a new kind of phenomenon, though, that maybe the reason there isn't any legal repercussions is because
it's
unexplored. It's kind of but at the same time, how would you? Like, how would you?
That presents another question. How many times a day would you say you get spam callers trying to sell you something?
All the time.
Trying to illegally take your money.
Oh yeah, I've got.
It's just becoming commonplace in society.
Yeah,
it has very much
and
to be scammed.
You can go to the FTC's website and put your phone on like do not call list. But if they call you, what are you going to do? They're not even in the United States half the time. And suing somebody who's not in the United States is like a whole other thing.
That's right.
And I mean, even the same for emails. If you tell somebody you want to be taken off their list and they don't stop, yeah, you can report them to the FTC. But what then? Like,
how does that better? How does that better your life? Right? You know what I mean? I get 4 or 5 a day.
It's crazy
Yeah.
that there's just nothing can be done in this technological age, but it means that you have to do your due diligence, like you said. So if I were to go to a financial planner and say, hey, listen, there's this guy, he's an SEO guru. He wants me to pay him $10,000 to get this course. And my financial planner said, I think this is a great move for you, and it didn't work out. Is that still your responsibility?
It's still your responsibility, right? So your financial planner, number one, they deal in markets. They deal with your financial planning, but they deal in markets that are all constantly going up and down, right? If you ask them, that's like if you came to me and said, what's your legal advice about this SEC guru? I'd say, I don't have a legal advice.
SEC guru.
Or
SEO.
SEO guru. You can tell how technical, but you can tell we're in the South as well. But I wouldn't have legal advice.
But you also would be responsible and say, hey, I don't know anything about that.
Don't know anything about it.
And not many,
Clearly.
There are a lot of people who would be more money motivated maybe and be like, sure, you retain me for this amount. I'll tell you what I think and then send you off on your way and it's on you. So it's kind of, I don't even think it has so much to do. I think this is something that's been happening for a long time before social media has been happening. But now we just see it. It's like slammed in front of our faces all the time that now it's especially hard to get away from it and realize, okay, there's actually nothing you can do except do your own research. But then like we were talking about with, contracts and forming an LLC, even when you go and Google something, like you're going to get more blog posts written by random people who tell you, yes, this is a good idea, or no, this isn't a good idea. So it's like, how do you know? Where do
it's
you go?
really hard to discern now what's credible and what's not
That's
credible.
right.
It's so easy to fake it.
With social media now, everybody can be an expert and hide behind.
And that's kind of why we started this, is because we were really tired of seeing people who don't know what they're talking about influence people to do things when, sure, maybe it'll work out for them or maybe it won't, but what are your qualifications to give this advice? It doesn't mean that you need a degree in law or like you don't need to be a lawyer to answer certain things maybe, but hearing it from a lawyer like certainly feels a lot better. And you're going to hear the flip side of what can happen if you don't, because that lawyer will deal with these situations that don't work out. So I guess like we're really grateful to have you on here to like freely share your expertise with people who want to learn, because nobody's going to listen to this who doesn't want to do better. Like people are here because they want to do better, and that means you're here because you want to help people.
Some of the best choices you can make as an individual entering into a contract, as individuals forming a business or business, anything to do with contracts. Remember, forming a business is you're entering into a contract. Have those tough conversations up front. Transparency, clarity, negotiation prior to entering into the contract. These things, if they would have been done early on, would settle so many disputes without needing to litigate, without filling up the courts with these civil issues. Some of them can't be. Some of them can't be. Negligence in the work performed, that sort of thing, that's typically going to be a contractual dispute. But be transparent. If you're a business owner and there's something with you that's non-negotiable, let's say that non-negotiable item is if somebody's an hour late, then their refund, then the deposit they made is non-refundable. If in your business that is a non-negotiable for you that you won't let slide, let them know that early on. Have that conversation with them. Make sure they read page 1 of the contract that discusses that non-refundable. Because not only as an attorney, but as a husband, as a father, as a consumer, that means a lot to me because you're not trying to hide the ball. Mm-hmm. Have those conversations with people that could be awkward, but I think typically what you'll see a sense of empowerment in your business because you're not getting walked on. Here's something that's important. My time is valuable. I'm not going to wait around an hour. And we're just using this as a hypothetical. Not only will you be empowered in your business, but you'll also be pleasantly surprised by the responses that you get.
I think most people want to be helpful in the process. Most people.
Put it in writing. Always put it in writing. Have the conversation, whether you're entering into a business with somebody or you're entering into a contract for a service or a product. Have the conversation early on about what the contract says. Keep yourself open as a business owner to have that conversation. Remove the awkward. And I would certainly say if you have a contract that you're going to use time and time again, have a competent legal professional take a look at that. Have a lawyer review it for you.
And we also want to thank Garrett Murphy for being here. Garrett, can you tell us a little bit about your practice and what you specialize in? This way people can contact you if they need your services.
Sure. Yeah, I have a unique history, I think. I was a financial advisor for approximately 12 years prior to becoming an attorney. So I do estate planning, but I also do litigation. On the litigation side, do a lot of contract work, a lot of business formation, business disputes, also negligence, medical malpractice, vehicle wrecks. I pride myself on my practice being a boutique law firm. It's not necessarily volume. It's not quantity over quality. Customer service is number one in our business, in my practice. So if anybody ever has any questions or always feel free to reach out. The website is www.garrettmurphylaw.com.
Thank you, Garrett, for being on our new podcast. And I can't wait to see where this goes.
Yeah.
It's going to be awesome.
Thank you both for having me. I enjoyed
Of course. Thank you for coming. While we aim to provide you with practical and knowledgeable advice, it's important to do your own research and consult with a professional before making any decisions that could impact your business.
The information we provide is for educational purposes only and should not be taken as legal, financial, or any other professional advice.
And with that, we want to thank you for tuning in to Clever Entrepreneurship Beyond the Boardroom. Until next time, keep building
And growing your business.